Okay, so welcome everybody to today's presentation. Just a couple of housekeeping items that we have. If you just wanted to put yourselves on mute while the presentation is going on, and then feel free, you could unmute later on near the end, like when we go to ask questions, or if you feel more comfortable and want to put your question in the chat, you could do that as well, and I could read those back. Another thing, just a quick reminder that we do have our webinar right after this at 12:15 for the WEOC loans. If you're applying or thinking of applying for some funding out there, you're more than welcome to join, and you could send me an email to makingadiffrence@pero.ca if you want to get the link, and I can send that off to you. So without further ado, I wanted to welcome our guest speaker today, Shokouh Abadi. I'm sorry, I hope I've said that right. And I'm just going to read her bio here. Okay, so Shokouh Abadi, a barrister and solicitor in Ontario, is the founder of Kimig Law and a TEDx speaker. She has extensive experience in business law, international commercial law, regulatory compliance, and anti-money laundering, and has taught various courses of law, including business law and contract law at different universities in England and Iran. She holds a PhD and an LLM, Masters of Law in International Business. Welcome. Glad to have you here today.
Thank you, Lori. Thank you so much. Hi, everyone. I'm so excited to be here and present the first session of Business Law Bootcamp. As you may know, this Business Law Bootcamp is going to be a series of webinars. We are going to have 3 sessions covering different topics related to scaling up your business. The first session today will be about agreements and contracts. Of course, welcome to this Business Law Bootcamp for scaling up a business. And as I said, today we are going to discuss and cover the topic related to agreements and contracts. I would like to remind that this is just a presentation and is for educational purposes. And if you have any specific matter, question, or case, I highly recommend that you seek legal counsel and consult with a lawyer, because these are going to be general principles of law. And of course, my goal is to present these principles and increase your knowledge of law. But for any specific matter and question, please consider to consult with a lawyer. This is the agenda for our today's session. I'm going to start with explaining some basic concepts. As you saw the title in the first slide, agreements/contracts. So these are the 2 main concepts that I'm going to explain, whether they are different or they're the same. After explaining these terms, in the second part, we will see how a legally binding agreement is formed, or what are the elements of a legally binding agreement. Then we will discuss different types of contracts, the process of making a contract from starting to conclusion and finalizing a contract. Then I will show you the structure of a typical contract and the different sections and parts of a general contract. Then I will give you some general tips that you may need to consider when drafting or reviewing a contract. And finally, I will name some and show you some samples of contracts that are usually used in the stage of growing up a business. If you have any questions, please raise your hand or raise the hand icon in Zoom. And if you want to write it down, as Lori said, please feel free to write your question and we will get back to your question at the end of this session. So before I start the conversation, I go back one slide. I may ask you a question. Do you think agreements and contracts are the same or are two different terms? And if you've had the experience of making a contract, what was the name of that document? Did you use agreement or contract? What's your opinion about that? Do you think these are two different terms or these are the same? If you could share your thoughts or yes,
yeah,
please.
So I've done letters of agreement with people, but then when I did a licensing agreement with people, I did a more contract instead of a letter of agreement, right?
So you think these are different terms or that these are the same? Like what's your—
Well, I felt that the letter of agreement was between you and me and the contract was legally enforceable.
Right, yeah. That's correct, yeah. So as you can see here,
Carmen, did you have something to add?
Basically, an agreement is not legally enforceable. Is what I was going to say. It's like an informal agreement between people, and then the contract is formal.
Exactly, yes. So agreement and contract are sometimes they are used interchangeably. So even lawyers, sometimes they use the term agreement, sometimes they use contract. But in a pure legal sense, these two terms are different. As you can see, agreement has a wider scope and it covers also contracts. Whereas contract has a narrower scope. In other words, all contracts are a type of agreement, but not all agreements are contracts. So that's why sometimes even lawyers, as I said, they use the term agreement, sometimes they use contract. But as you all mentioned, like Elizabeth and Carmen, you both mentioned, the difference between agreement and contract is the term, like being legally binding. Contracts are legally binding agreements. But there are some other types of agreements that are not legally binding, such as the letter of intent is a type of agreement, or memorandum of understanding, term sheet. These are all agreements that are not usually legally binding. In other words, they are not legally enforceable. But contracts are a type of agreement that are legally binding and they can be enforced by the power of law. Agreements can be formal or informal, but contracts are formal agreements. Is there any question? Is it clear so far? There's no question?
No, nothing in the chat. Does anybody have any questions?
No, okay. And as you all know, contracts are the backbone of all businesses, because at some point during the term of your business, you would need to—
Can you plug this in, please?
Sorry about that. Go ahead.
you would need to make a contract. For example, when you want to hire an employee, or for your license, or a non-disclosure agreement in order to not to disclose the information of your company to third parties, you would need a contract anyways. Do you think the contract that is legally binding has to be written, or what are the elements that are required to make that agreement legally binding, or contract as a legally binding agreement? Being in writing is not an element to render an agreement legally binding. This is sometimes we think that if we write down the terms and conditions and we sign it, that's a legally binding agreement or a contract. Not really. The main elements that are required for a legally binding agreement or a contract, as you can see, are, first of all, offer and an acceptance, then intention and consideration. These are the four main pillars. Along with these four main pillars, we have also other elements: capacity, privity, certainty of terms, and lawful purpose. I will try to explain all these elements so that you get a sense of what these elements are. So first of all, let me start with an example. Let's say I want to sell my cell phone. I make an offer. I say, I sell my cell phone for $500 to Elizabeth. This is a statement by me of a willingness to make a contract to sell my cell phone. And without any acceptance, this is just a statement. If Elizabeth says that I purchase your cell phone for $500, then that is an acceptance. It mirrors the exact terms that I used, selling a cell phone for $500, and Elizabeth accepted the exact terms. So now imagine that Elizabeth says, I purchase Shokouh's cell phone for $450. What would be the result? Do we have any contract here? I said $500, and Elizabeth says $450. Is there any contract? No, because I offered, my statement was selling the cell phone for $500. Acceptance must mirror the exact terms of offer. If it doesn't mirror that, if it changes the terms of offer, it kills that offer. And it's called a counter offer. Even if I accept that, even if I say, okay, I sell it to you for $450, my offer, my first offer is gone. Now, Elizabeth has made a counter offer, a new offer. And if I say yes, then I've accepted that. Then there is a contract, but with different terms. And if I don't say anything, if she says, I purchased Shokouh's cell phone for $450, and I don't say anything, and I sell it to Carmen. Later on, if Elizabeth comes to me and she says, that is my cell phone, I purchased it for $450, there is no legal claim for her because there was no contract. There was a counteroffer which was not accepted by me. So there was no legally binding agreement. So that's how a legally binding agreement or contract needs an offer and an acceptance that mirrors the exact terms of that offer. And of course, there must be an intention. My intention to sell my cell phone and Elizabeth's intention to purchase that, that cell phone with the same terms and conditions. The other element of a contract is consideration. Consideration is the value that one of the parties provides in exchange of the other's promise. And what does that mean? So I'm selling my cell phone. I don't give it for free. If I give it for free, that's not a contract. Even if Elizabeth gives me $1 in exchange for this cell phone, that is considered a consideration. The value is not important. Even if it's minimal, it's not important. What is important is that there must be a value in exchange of the other party's promise. My promise is to sell my cell phone, and there must be another promise in exchange, or another value in exchange of this promise. So this exchange of values must be present in order to make a contract. Of course, if she pays me $1 in exchange for this cell phone, we have a consideration. Later, I can claim based on other doctrines such as unconscionability or unfairness that this contract was not fair, and that may later on affect the contract. But we have a contract. The contract is formed because it has the main elements: offer, acceptance, intention, and consideration. Is there any question so far? Do you have any question?
Nothing in the chat. Does anybody have any questions right now?
Okay.
Okay.
There are some other elements such as capacity. For example, a minor, a child, cannot make a contract because under 18 years old, they don't have the capacity to enter into legally binding agreement. Or those who are mentally incapable, even if they make a contract, that is not a legally binding contract because it doesn't have that element. Privity means the parties, the terms of the contract is binding on the parties involved in the contract. It doesn't affect third parties. Certainty of terms means the terms of the contract should not be vague. It must be exact and certain. And lawful purpose means that, for example, we can't make a contract to and make a promise to sell drugs or kill somebody because the purpose is not legal. So the contract would not be even legal. So these are the main elements that must be present in order to form a legally binding agreement. If any of these elements is missing, then we won't have any contract. As I said, like the example that I mentioned for selling my cell phone without an acceptance. There is no contract and there would be no legal claim after that. Once a contract is made, we need to know what are different types of contracts. Again, I'll go back to my first question. Do we need to have a contract in writing, or even oral agreements are legally binding? Or do we need to have two parties? Yes, we need to have two parties. But what is a unilateral contract? So I will explain in more detail here. Different types of contracts. We can categorize contracts based on different factors. One of them is based on the number of parties involved in the contract. Of course, for any contract, we need at least two parties. So then what is a unilateral contract? Can you guess what's a unilateral? We cannot make a contract ourselves. Then what's a unilateral contract? Any idea? Yes, please, Elizabeth.
No, I don't know.
Right, okay, I thought you said yes, okay, that's a no, you don't know. Okay, a unilateral contract, let me explain first the bilateral contract, then I will get back to unilateral contract, then it would be easier to understand. A bilateral contract is exactly like my example, what I said. One party gives a promise, the other party another promise. So I promise to sell my cell phone for $500. Elizabeth accepted that and agrees another promise to pay me $500. So there are two promises here. This is bilateral. Most of the contracts are like this, two parties with two promises. In a unilateral contract, one party makes a promise. Have you seen those, like sometimes on the street when you're walking, there's a piece of paper on the wall of a lost dog or a lost cat, a number, and sometimes they might even mention a prize or an amount of money. If you find this dog, we'll pay you, let's say, $500. That is an offer. That's a promise. If you find that dog or that cat, the owner promises to pay you an amount, $500. But who is the other party? The public. Any person who finds that dog or that cat and can get that $500. So the term of that contract, that is a unilateral contract, an offer to the public, to the world, and whoever performs and acts upon the terms of that contract, that offer, accepts that. And then the contract is made. So at the beginning, there is no acceptance. The acceptance is by performing the terms of the offer. And whoever, the public, whoever performs that, the terms of the offer, has accepted the offer, and then the contract is made. So that's why we call it unilateral contract. Because first there's an offer. The other party is not a particular person, is the public. And whoever, as I said, performs and acts upon the terms of the offer, accepts it. That's why we call it unilateral, because there's one promise at the beginning. There is another way to categorize contracts, and that's based on the way offer and acceptance are communicated. Sometimes contracts are express. As I said, like, I'm going to sell. I sell my cell phone for $500. This is expressly mentioned, and it's oral. I verbally communicate the statement to the other party. And the other party accepts that, even if there is no signature or signing, there is nothing in writing, the contract is made. Because those elements, as we mentioned, those elements, as long as those elements are present, we have a contract. There's no need to have a document, signature. Those are formalities. Sometimes contracts are in writing. There is no need to have a written document to have a legally binding contract. I emphasize that there is no need. Sometimes it's mandatory. For some contracts, it's mandatory, it's obligatory to have written contracts. For example, when you want to purchase or sell your property, that it's mandatory to have written contracts based on the statute of frauds legislation. Or for some consumer contracts based on Consumer Protection Act, you need to have written contracts. But generally, there is no need. Those are exceptions. Contract can be oral or in writing. And sometimes you don't even expressly transfer and communicate the terms of the offer or acceptance. And contract in this case is implied or by conduct. For example, when you want to buy a soda or a can of or a bottle of water from a vending machine, you just like tap your card or insert the coin, you get the bottle of water. That's a contract, and it's made by conduct. There is no oral or written communication of offer and acceptance. That's implied and by conduct. Or when you just give money to the vendor of, let's say, newspaper, or you want to buy a coffee, you don't say anything. You just tap your card and get your coffee. That's by conduct or implied. That's a contract, a legally binding contract. So there are different types of contracts, different ways of communicating intention, offer, and acceptance. As long as those elements, these elements that we discussed here, are present, we have a contract. Any questions so far? All right. I'm going to talk about the process of making a contract. In business, usually conclusion of a contract or making a contract starts with negotiation. The negotiation stage is not really a legal or legally binding stage. In the negotiation stage, the parties usually discuss the business terms, their needs, goals, and sometimes they may collect and gather those informations that are exchanged and write it down on a document and have a document called, let's say, memorandum of understanding, or term sheet, or letter of intent. These documents, as I mentioned in the first slide, these are agreements. They agree. They make sure that they are on the same page through these documents. But these are not legally enforceable. They just make an arrangement and agree on some general points. And these are just some roadmap and guidance for their future legally binding agreement or contract. Some of these documents in the negotiation stage can be legally binding. For example, in selling or purchasing a business, sometimes it is necessary to have a non-disclosure agreement or NDA, because you want to know the business that you're purchasing is in a good stand. It's not bankrupt or does not have any debts. So you would need to get some information from the other business to make sure that it's a clean and proper business to purchase. Before entering to the main contract, which is purchasing the business, you need those information. And the best way to do that is in the negotiation stage through an NDA, a non-disclosure agreement. That agreement is legally binding. It's a contract, although it's in the negotiation stage, but it is binding. You get the information from the other party. You make sure that that business is clean and there's no problem with that. And based on that, you enter into the main contract, which is purchasing the new business. So in the negotiation stage, we might have some legally binding contracts, but most of the documents that are exchanged and signed in the negotiation stage are not binding. They are not legally binding. They are mostly agreements, such as I said, MOU. They just the parties just cover the main points and the main terms of their agreement, and then they transfer it to their main contract in the next stage, which is drafting. After negotiation, one of the parties usually is responsible or takes charge of the writing or drafting the contract. Usually and generally, the party who drafts the agreement has more power in terms of drafting the contract in a way that is more beneficial for them, because the other party will just review the contract and may change some terms and conditions, but the party who drafts the agreement, this is a general rule. There might be some exceptions, but generally the party that drafts the agreement has more power to insert the terms that he or she wants to be inserted in the contract, because it's more difficult to change later. Rather, like, it's better to draft from the beginning what you want. So it's usually recommended, if you want to if you have any specific terms that you want to insert in the contract, it's better to take charge of drafting the contract. And the other, once the contract is has been drafted by one party, then the other party reviews that contract. Once both parties have agreed on the terms and conditions, then they sign it and the contract is made. That's the conclusion stage, and it's finalized. So that's the life cycle, or the process of making a contract. It starts with negotiation and it ends with conclusion. Any questions so far? Is it clear? All right.
Yeah, nothing in the chat there, but if anybody has any questions. No, I think we're good right now.
There is no like standardized form for making a contract. A contract can be, as I said, verbally made, or be in writing, by conduct, but generally in business, most contracts are made in writing, because it brings more safety and assurance for the parties, because they can record their discussion and their agreements, and it can later be used as a proof if they face any problem during the term of enforcing the contract. So it's better always to have a written agreement, a written contract, And there is no specific form or template, but again, generally, this is the structure of a contract. These are different sections that are generally covered in a legally binding agreement. I will show you later a sample, then you can see different parts in a contract. But it starts, usually a contract starts with the title. Maybe I could share it here. I don't know if I can, if I switch my page, you would be able to see. Can you see my Word document here? All right.
I still see the structure of a contract on there.
Yeah, maybe because I have to stop sharing. And so I will go through different sections, then I will show you the sample later. It starts with the title of the agreement or the contract. It's very important to choose the right title, but what is more important is not the title, it's the intention of the parties. So let's say if the parties name their contract a sales agreement, but what they have intended or what has been agreed upon is not sale of any product or services, but it's lease of a product or a property, then the title does not change the fact. What is important is the intention of the parties. The title is just something that the parties put on top of their documents. But if they face any problem and they go to the court, the judge will decide based on the intention of the parties. But it's always good to choose the right title in order to avoid any problem. After the title, the first paragraph is usually the introduction of in the introduction section. Usually the name of the parties are provided, the place of incorporation of their entity, if it's an entity, their residence, whatever. Some general information about the parties is provided in the introduction section. In the paragraph right after introduction, usually the parties provide some information, about their background. It's called recitals or preamble. How the parties have reached this stage to make a legally binding contract. And it starts usually with whereas, if you have seen this term before. Whereas, let's say, Shokouh wants to sell her cell phone, and whereas Elizabeth intends to purchase a cell phone, now therefore they have agreed upon the following terms and conditions, and they are going to make this contract. It provides some information about the background and their intention. And why is it important to have recitals or preamble? It provides some more clarity about the intention of the parties. And in case the parties face any problems or any dispute between them arises, then the preamble or recital section can clarify and help the court or the judge or the dispute resolution mechanism, whatever it is, the arbitrator or the judge, to find out about their intentions. So recitals is a good tool for interpreting the contract. After recitals, usually definitions of the main terms and concepts are provided. And it's good to have this section because, again, it will avoid any ambiguity or any misunderstanding of any term. It's good to have definitions of the main concept, especially if a term is used several times in the contract. It's good to have a definition of that term. I'll try to go faster because I just noticed we have just 15 minutes left. So conditions and covenants, representations and warranties are the most important parts in a contract, the main body. They explain the promises, obligations, rights, and duties of the parties, the values that are provided and exchanged in a contract. For example, in our example, I sell my cell phone. I have a duty to deliver that cell phone to Elizabeth, for example, on a specific date. That's the covenant. That's an obligation that I have to perform. And Elizabeth has the right to receive my cell phone on that specific date. And she has, again, a duty or obligation to give me the money. And I have the right to receive the value or consideration in exchange of my cell phone. These promises, obligations are all discussed in the main body. Remedy is usually explained in the section after explaining rights and obligations, and that is the sanction, or what if one of us don't like. What if one of us doesn't perform our duty? What would happen to the contract? Because it's a legally binding agreement, it's legally enforceable, it's legally binding, so there must be the force of law is behind that. Like, for example, the court can force the other party to perform his or her duty. Or there might be some damages for not performing an obligation, or even rescission or terminating the contract. These are the remedies for not performing a contract. And that is exactly what is required. And it's the distinctive feature for agreements, non-binding agreements and contracts. There are some clauses called boilerplate clauses or miscellaneous clauses. These are usually towards the end of the contract. Most contracts, they have these terms and clauses. Like, for example, force majeure. What if an earthquake happens and we cannot perform our duties? What if what is the dispute resolution mechanism? What if a dispute happens between the parties? What's the best way to resolve that dispute? Court, arbitration, and mediator. These should be discussed and provided here in the dispute resolution clause. What's the applicable law? If it's especially in international contracts, applicable law is very important. Which country or which jurisdiction has the governing power or governing law to the contract? Then some other clauses, how to communicate, how to send, or when some changes are made to the information of one of the parties, how to communicate to the other party. And when the contract is terminated, or the duration of the contract must also be provided in the contract. And finally, the signature section, and if there is any scheduled or exhibits towards after the signature section, at the end of the contract will be attached to the contract. It is a general template of a business contract. Some general tips in drafting or reviewing contracts: always use defined terms. If there are some terms that are used, as I said, several times in a contract, try to define it at the beginning, because that's very important to avoid any ambiguity and any misunderstanding. So always use defined terms, avoid incoherence, use clear language The simpler, the better. Avoid any complicated terms or vague language. The clear language is always the better. Be precise. Provide an exact amount or an exact value for anything you have, not an estimate, because that can cause problem. Always try to use very short sentences, again, to avoid any ambiguity. Contract is not a place for detailed facts. It's better to keep it short, simple, and accurate. And try not to repeat a clause that you already have in a contract, because the second clause or the second part can affect the first one and again cause ambiguity and a dispute. So try to omit repetition. These are some general tips in drafting and also reviewing a contract. And these are some contracts or agreements that businesses would need in growing or scaling up stage. You may have signed some of these, made some of these contracts so far, but these are some of them. Shareholders agreement, when there is a corporation and different shareholders, and they want to agree on the terms that how their corporation should run. Then they would need a shareholders agreement. Joint venture, again, when some businesses, they join together. In the next session, we will discuss mergers and acquisition, and joint venture, I will also cover joint venture a little bit. When some businesses, they join and want to collaborate, work together, they would need joint venture agreement. Partnership agreement, employment agreement, independent contractor agreement, sales agreement. Sales agreement is so common. Whatever you want to purchase, any device, any equipment, that is sales agreement. Distribution agreement, confidentiality agreement, non-disclosure agreement. As I mentioned, NDA is very important in especially in growing up stage. Non-competition agreement, non-solicitation agreement, service agreement, and supply agreement. These are some, like there are plenty, like many other agreements, but these are some of the most common ones in the scaling up stage. I will quickly show you a sample of a contract so that you could see what I explained in a real contract. This is a master service agreement. As you can see, it has a title. And here this is the first paragraph. It's that introduction. It introduces the parties. It's made by and between one of the parties and the place of the business of that party, and what is it called during this contract, consultant. And the other party, jurisdiction of incorporation, and together they are called the parties. This is the preamble or recital section that I mentioned. It gives you the background of how the parties reached this stage. Each of them, the consultant, one of them, and the client, the other party, and their intention to conclude this contract. Then the obligation of the parties. Each of them has some obligations towards the other. You can see here, this section is the longest or the more important part of the contract. It provides the obligations, explains in detail what are the duties of each party towards the other. Confidentiality, these are all the obligations section. And then term and termination of the contract, the duration of the contract. And from here, we have the boilerplate or miscellaneous clauses, entire agreement, notices, amendments, modification, assignment, governing law, arbitration, dispute resolution, the way they can resolve their disputes, force majeure, counterparts, and then signature. They sign here, and then the schedule or annex is attached after the signature section. This is a sample or a template of a master service agreement. All right, I go back to the presentation. I think, yeah, this is the last slide. All right. Any question, any comments, anything?
Yeah, for sure. There's nothing in the chat right now, but if anybody has any questions, you're more than welcome to unmute and you can ask any questions that you have. Elizabeth?
I notice sometimes with the non-compete contracts, some people don't enforce them. They don't bother going back to the employee when they take a job in another similar business or they start a business. Why do you think that is?
They have the power to do that. They have a claim because that's a contract, but it really depends on the relationship between the parties. Sometimes it's better not to sue or claim against a party because that may affect the reputation or the business relationship. But legally, they have this power and claim to sue that person. It's because it's a legally binding contract. That non-competition or non-compete clause, it can be a clause in the main contract, or it can be a separate agreement. So it has the same power or the same force of law if it's a clause in a contract or a separate agreement, a separate contract. They are legally binding. But if they don't use this power, it's up to them. Sometimes, as I said, if they want to, it's mostly for the reputation concerns and maintaining the business relationships. These are the main concerns, but nothing legal, really.
Yeah, it always surprises me.
Yeah,
you know, if you're going to do a contract with somebody, why you wouldn't follow it up.
Exactly, yeah. So yeah, any other question, any other points, comments?
Go back to the slide before this, the types of contracts.
Sure. This one or?
Yeah. Okay, yeah, no, I'm okay with all the rest. I just, the non-competition one has always, I wondered if they were hard to enforce or, you know.
No, not really. It's something that they are like, if they don't follow and they don't want to claim against the party who has breached the terms, it's their decision, but it has the power and it's enforceable.
Well, thank you. It's a lot of information there. Okay,
You're
does
welcome.
anyone else have any questions?
Nothing in the chat. No, do you have, oh, you just had your slide up there with the, with your contact information, so if anybody needs to.
Sure, yeah. Thank you.
Yeah, so if anybody needs to and would like to reach out, please, all her information is here. She will be back. I just have to look for I don't have my calendar here. Do you remember the date that we picked? I'm so
Yeah,
sorry.
I have it here.
Oh,
Because
right here, yeah, I do. In May
May 10th,
10th, and in June, I think it is
June 7th.
June 7th, yeah. So the next two will be on those two dates. So we hope that you're able to join us for those last two. So, oh, go ahead, Elizabeth.
I wondered what the topics were for the other ones coming up.
Sure. On the 10th, May 10th, we will cover mergers and acquisitions. And on June the 7th, we will cover employees, like hiring your first employee and employment contracts, independent contractors, difference between these two contracts. But first we had to pave the way and explain what a contract is in order to be able to explain mergers and acquisitions and employment contracts.
So June 7th is about the employment contracts. That's great. Yeah, I'll come back
And
for
May
that.
10th is mergers and acquisitions, and it's mostly related to purchasing and selling business, joining to other businesses. And that is something that businesses would need to consider when they want to grow and scale up.
Yes. Yeah, thank you so much.
You're welcome.
Yes, thank you. And Tracy says good session and she has to run. So thank you, she says.
Thank you so much. And looking
Yeah.
forward to see you all on May the 10th.
Yes, well, we are too. Thank you so much for this information. It was really valuable and we really appreciate you being here.
You're welcome. Thank you. And have a
Yeah.
great day, everyone.
You too. Thanks, everybody.
Bye.
Bye.